The process of selling a company is actually pretty complicated. Selling a company really starts many, many years before you even know that you want to sell or even that you're ready to sell a company. Selling a company basically entails showing the buyer that what you've built is really worth and it is what you say or think that it is. So the first stage is, once your company approaches probably a few $1,000,000 in revenue, you will get many offers from buyers. There are people out there looking to buy companies all the time. These can be private equity, family office, you name it. You may get offers in your email, offers to start a discussion of looking at your financials or discussions and approaching you basically to learn more about your business. And in this stage, you may be okay with sending some documents, some basic financials. You might want to ask for an NDA to make sure that your documentation is not divulged anywhere. And if the buyer likes what they're seeing in that preliminary phase, they will send you, sometimes they send a letter of interest where they say, we really are looking at this. And then you continue to send maybe even a few more detailed documents. Then it gets to the stage where the buyer prepares a letter of intent. A letter of intent is a document that explains the purchase price, the assumptions, and the process to basically get to what we call the definitive agreements. The letter of intent is signed by both parties and has binding portions and non-binding portions. Binding portions are those that are legally enforceable, and the non-binding ones are simply expectations or assumptions or things that may allow the buyer to change some of the terms or things they put in that letter of intent. You're looking probably at 4 to 5 pages, usually is very normal. Once the letter of intent is signed, then the parties begin the due diligence process. The due diligence process has primarily 2 parts to it. The first one is usually the financial. And the buyer in the financial portion of the diligence will bring their entire accounting team, usually a vendor, a large accounting team that will look at your financials and make sure that they are good. So if you're getting ready to sell a company, make sure you as a seller get your financial in place today. Don't wait until you're ready to sell, do it now. And if the financial documents look good, then the buyer will then be ready to bring their team of attorneys to do the due diligence, which is basically reviewing. The way I like to describe due diligence is you basically turn your entire legal operation, every contract, everything, you turn it over to the buyers so they can scrutinize. And they look at contracts, regulations, they look at taxes, they look at how you service your clients, they look at your website, they look at absolutely everything. Because in this process, the buyer wants to make sure that they are buying a good company, that, for example, they're not buying a company that will bring them problems or a liability. So they also want to know if you have litigation or claims or letters from a customer claiming something or refunds and things of that sort. It is a very intense process and you should be ready for it. If the financial and legal due diligence aspects go well, then your last stage will be negotiating what we call the definitive agreements. The definitive agreements are essentially what you would hear as the asset purchase agreement, the membership purchase interest agreement, the stock sale agreement, etc. And that is usually for our clients that are selling for many, many millions of dollars. It's a stack of paper, very, very thick. It's a lot and it takes a long time to negotiate. And in that document, basically, you will negotiate everything. Basically, it's like putting your entire company in paper, describing the company in paper, describing all the good things and the bad things about your company in paper, and then making promises to the buyer. And the buyer will make promises to you relating to the purchase price, the earnouts, and many, many other aspects. One of the key things that are getting negotiated in that definitive agreement is the representations and warranties. And that is the one where us as the seller's attorney are putting a lot of attention to make sure that the reps and warranties are not overly expansive, and these are things that our clients can actually meet. And then after we sign the definitive agreements, which is basically the closing, you get money in your bank account, which is great, and we're happy for you. And then we have the post closing is when that earnout and employment agreements and all of that for these sellers kick in. So it's a long process. It can take many, many months depending on the size of your sale. But it's also one of the most rewarding moments for our clients, especially the ones that are selling their company for the very first time. We are so thrilled that all the work and time and effort that they have put in their company pays off. And then we're always excited to see clients then become, some of them become serial entrepreneurs, some of them retire, others start new companies. So it's really exciting to also see for us as attorneys, the process that our own clients follow after they sell their company for many, many millions of dollars.